Hi, you're watching Voice for Men India. This video is going to be a little long, but if you're genuinely interested in knowing the history, the introduction of Section 498A IPC, what were the past judgments, and what is the extent of misuse, please do watch this video right till the end. First, let us understand what is Section 498A IPC. Let us understand the legal definition first. Whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with an imprisonment for a term which may extend to 3 years and shall also be liable to a fine. Let us simplify this for you. If you are a married woman in India, you can file a criminal case of cruelty against your husband, in-laws, and every single relative of the husband, even if they have never cohabited in the same household. Many a times, the unmarried and even married siblings of the husbands, along with their spouses, who are living in perhaps a different city or even in a different country, are served with this FIR only to teach a lesson to the entire family. Let us understand when was this law introduced and what was the objective behind this law. Section 498A of the IPC was introduced in the year 1983 by the Congress government as an amendment to the IPC to address the growing concern of domestic violence and harassment faced by married women in India. Let me tell you, this IPC is applicable to all men irrespective of religion or caste. Section 498A was enacted with an objective to prevent torture against married women by their husbands and family, particularly in connection with the demand for dowry. In order to deal with the menace of cruelty to married women, the Parliament then brought 3 levels of legislative changes in the 1983 criminal law. Chapter 20A was inserted by the Indian Penal Code 1860 through the provision of Section 498A with an object to penalize the husbands or the in-laws who torture or harass the wife or daughter-in-law with an aim of coercing or forcing her to meet any unlawful demands or to drive her to take away her own life. Along with this, Section 304B, defining the dowry death of a married woman, was also inserted in the IPC of 1860. Section 113B was inserted in the Indian Evidence Act regarding the presumption of the death of a married woman. And Section 174 of the Criminal Procedure Code, that is CRPC, was also amended, and it mandated the inquest by the executive magistrate in cases of death or suicide by married women within 7 years of marriage. The offence of 498A IPC is both cognizable, non-bailable, and also non-compoundable, which means that these are serious crimes that cannot be settled mutually between parties and require complete trial for justice. Let us understand the rampant misuse of this law over the years. A law that was meant to protect married women who were victims of domestic violence had been turned into a tool to settle scores and unleash vengeance against husbands and their families. As times passed, our society had evolved, women were educated, aware of their rights and laws, and thus our courts started witnessing multiple false matrimonial cases by women only to harass their husbands. In the year 2005, the Supreme Court in Sushil Kumar Sharma versus Union of India observed that the object is to strike at the roots of dowry menace, but by misuse of this provision, a new legal terrorism can be unleashed. The provision is intended to be used as a shield and not as an assassin's weapon. If cry of wolf is made too often as a prank, assistance and protection may not be available when the actual wolf appears. What were the guidelines of arrest in Section 498A prior to 2014? The way this law had been originally designed was completely lopsided and fully empowered a married woman to get her husband and in-laws arrested on a mere criminal complaint. Often, the modus operandi followed in such cases was the husbands would be picked up by police from their organizations on a Friday evening, thrown into custody for 2 days until they could approach court on the following Monday for bail. After years and decades of such inhuman practice to protect only one gender, the Supreme Court laid down certain guidelines for arrest under Section 498A through the Arnesh Kumar versus State of Bihar judgment in 2014. With these new guidelines, the Supreme Court hoped to put an end on the arbitrary power of arrest rested with the police. The Apex Court then quoted, "We believe that no arrest should be made only because the offence is non-bailable and cognizable and therefore lawful for the police officers to do so." To curb this absolute power of arrest given to the police, Section 41A of the CRPC was made mandatory. What is this notice all about? Now, whenever an FIR is lodged by a wife against her husband and in-laws, a 41A CRPC notice must be served on the accused within 2 weeks from the date of institution of the case, where the opposite parties are also given a chance and are required to appear and cooperate in the investigation. This effectively meant a stop on all automatic arrests purely on the word of the wife. Come 2017, Supreme Court issues new guidelines to prevent misuse of Section 498A IPC. To curb misuse of this one-sided law, a two-judge bench of Justices A.K. Goyal and U.U. Lalit laid down certain specific guidelines which mainly called for constituting one or more family welfare committee comprising of 3 members in every district. Every complaint that was now going to be registered under Section 498A received by the police or by the magistrate will be referred to these committees, and these committees will then have an interaction with the parties personally by means of telephone or any other form of communication, including electronic communication. While issuing these guidelines in 2017, the Supreme Court bench once again remarked that it is a matter of serious concern that large number of cases continued to be filed under Section 498A alleging harassment of married women. To remedy the situation, we are of the view that involvement of civil society in the aid of administration of justice can be one of the steps, apart from investigating officers and concerned trial courts being sensitized. The Supreme Court then also said that it was necessary to facilitate closure of proceedings where genuine settlement had been reached instead of parties being required to move the High Court only for that purpose. Cut to 2018, Supreme Court reverses these 2017 guidelines. A 3-judge bench led by then Chief Justice Deepak Misra, Justice D.Y. Chandrachud, who is the current Chief Justice of India, and Justice A.M. Khanwilkar withdrew these 2017 direction of setting up family welfare committees. Though this 3-judge bench acknowledged that there was misuse of the provision leading to social unrest, it said that the court could not fill in legislative gaps. Let us quickly show you some of the comments, observations that have come through courts pan-India in recent times. One can just do a basic Google search on the misuse of Section 498A and you will come across multiple observations and judgments from courts across India calling out the ill intent of wives who file such cases. Let us give you some examples below. In May 2020, the Punjab and Haryana High Court said Section 498A IPC is a weapon rather than shield for disgruntled wives. In July 2022, the Chhattisgarh High Court granted divorce to a husband after 22 years of separation, observing that Section 498A IPC cannot be used as a weapon to teach lesson to in-laws. In August 2022, the Bombay High Court Aurangabad bench quoted, "It is a fashion to rope in all poor relatives of the husband under Section 498A IPC, even if they never lived together." In January 2023, the same Bombay High Court Aurangabad bench quashed another false 498A case against a husband's married sister, stating that this was a classic example of roping in all family members to settle score. In August 2023, the Madhya Pradesh High Court made a strong remark against a wife, stating that women nowadays file a package of 5 cases against the husband and in-laws. In the same month, the Calcutta High Court too made a bold statement quoting legal terrorism unleashed by women misusing Section 498A IPC. But why are we discussing all this today? We are discussing this because on 3rd May, a Supreme Court bench comprising of Justices J.B. Pardiwala and Justice Manoj Mishra have once again echoed the same gross misuse of the anti-dowry law. The bench, in its observation, stated that where a wife complains of harassment or ill treatment, Section 498A cannot be just applied mechanically. Every matrimonial conduct which may cause annoyance to the other may not amount to cruelty. The top court also said that mere trivial irritations, quarrels between spouses which happen in day-to-day married life may also not amount to cruelty. Using very strong words against the utilization of police machinery, the Supreme Court added that this was nothing but holding the husband at ransom so that he could be squeezed by the wife at the instigation of her parents or relatives or friends. Adding further, the top court also remarked that many times the parents, including the close relatives of the wife, make a mountain out of a mole. Instead of salvaging the situation and making all possible endeavors to save the marriage, their action, either due to ignorance or on account of sheer hatred towards the husband and his family members, brings out complete destruction of marriage on trivial issues. The bench also said that the wife and her family members would approach police station at the very first instance, and this could actually destroy the fair chance of any conciliation between the spouses. Not just this, but the Supreme Court has also made a comment and a request to the Parliament. The Supreme Court questioned whether the legislature had seriously looked into the suggestions of the top court as made in earlier cases with regards to the misuse of this law. The bench also observed that the new BNS is nothing but just a verbatim reproduction of Section 498A of the IPC. The only difference is where they have changed the numbering from 498A IPC to Section 86 of the Bharatiya Nyaya Sanhita 2023. Accordingly, now the Supreme Court has requested the legislature to look into this issue, taking into consideration the pragmatic realities and consider making necessary changes in Section 85 and 86 of the BNS 2023 respectively before both the new provisions come into force. Now, what is our take in this? A law that was introduced 41 years ago needs to be reviewed, particularly with the evolving fabric of our society. 1983 was a period where Indians largely lived in joint families. Married women could have been subjected to domestic abuse at the hands of multiple family members of the husband. However, in 2024, when couples live in a nuclear family, can the same law be applied, embroiling every possible relative of the husband? There have been numerous cases where husband's parents have just visited their married son's home either for lunch or dinner, and when the marriage goes bad, these same old parents have been dragged to courts, run around courts for years and decades. We have also witnessed several cases of husband suicide or suicide of family members of a married man who have been falsely accused under 498A by the disgruntled wives. Section 498A is also not gender neutral, which means that a husband and his family cannot charge the wife or daughter-in-law for cruelty or domestic violence. While we have the strictest law in place for dowry prohibition, we do not have any law to prosecute wives who pressurize and threaten husbands for huge sums of alimony. Let us also tell you that most of these false cases are settled with monetary compromise or after properties are transferred to wives. Subsequently, both approach court, drop the FIR, and the cases are closed. As a society, every single citizen needs to voice their ranks against such legal extortion of husbands and their families. Yes, all laws are misused, but this is the only law which empowers a married woman to legally trap her spouse and in-laws for life until they do not converge on the negotiating table. What are your thoughts on this? Do let us know in the comments below. You can read the entire article along with the current and all past judgments in the description link of this video or on our website voiceformenindia.com. You can also follow us on our social media handles, which is X, Instagram, Facebook, Telegram @VoiceForMenIn. And do hit that bell icon so that you can be updated with the latest video as in how we broadcast them. Thank you very much for watching Voice for Men India. Namaste, Jai Hind.